fertility law is something that's kind of very much a new field and something that's very interesting. We're very passionate about what we do. But just to give you a little bit of background about me and where I come from, so you kind of get the context of what I'm talking about. I founded a law firm called NGA Law, which was the first specialist fertility law firm in the UK in 2009. And we work with families and fertility patients who are conceiving and creating families in lots of different ways, experiencing legal questions and needing to go through legal processes. So people conceiving through IVF, donor conception, surrogacy in particular, people in non-traditional family structures as well, so lots of LGBT clients. And we really love kind of helping people to create families. And in 2013, with my business partner, we created Brilliant Beginnings. And Brilliant Beginnings is a non-profit surrogacy agency. So as well as giving legal advice, through Brilliant Beginnings, we give practical help with the surrogacy side of things, both for parents going through surrogacy here in the UK and parents going overseas as well. So it gives you kind of a bit of flavour of the background in terms of the kind of work we do, both legal and non-legal. So for my talk, I was given a list of a few topics to talk about. So I've kind of divided the talk up into three of the kind of really key areas. So I'm going to talk a bit about legal parenthood if you're conceiving with either donor eggs or donor sperm or both. I'm going to talk a bit about co-parenting and known donation arrangements. And I'm going to talk a bit about surrogacy. And hopefully at the end we'll have plenty of time for some questions as well. So to think about egg and sperm donation, and really to start at the beginning in terms of legal parenthood, and why does the law matter? Why does it matter if you are legally a parent of your child? Well, there's a whole list of reasons why having that legal connection is really important. So first and foremost, it's a question of identity. So your identity as your child's parent, but also their identity as your child. So being a legal parent enables you to be recorded on a child's birth certificate. You cannot be recorded on a birth certificate if you are not a legal parent. Secondly, your right as a parent to make decisions for your child and your right to be involved in other people's decisions. So things about where your child goes to school, whether they have medical treatment, how they're brought up, whether they move overseas, all those sorts of kind of ongoing parenting decisions that you make as a child grows up. Your right to make court applications, so if you are with a partner and you separate, your right to bring an application if you're not allowed to have contact with your child. These things can be really, really important further down the line. And then the things that are to do with that connection with your child. So inheritance, your child's right to inherit from you either automatically if you die without a will or via your will if you make a gift to your children. And British nationality. So if you're British, do you pass your nationality to a child? So all of these things are part of that legal status of being a parent. So if you're conceiving a child through egg or sperm donation, there's an obvious question, who are going to be the legal parents of this child? So as far as egg donation goes, the law is really simple and straightforward, and it comes down to one rule. The woman who gives birth is the legal mother, and she's the only legal mother. So whoever has provided the egg, a donor, or perhaps the birth mother's partner, is not the legal mother of the child. So the only person who's a mother is the person who gives birth. So with sperm donation, it gets a little bit more complicated because what you're doing here is looking at the status of the person who is usually the partner of the birth mother. And the law in the UK is written all on the basis of let's look at who the birth mother is and let's look at what relationship she has with other people. So if the birth mother is in a married relationship, so that might be married to a man, it might be married to a woman, it might be in a civil partnership with a woman, and as from later this year, it might be a civil partnership with a man as well. But her spouse will then be the other legal parent of her child, even if that child is conceived with donor sperm. Okay, and that's the case unless her spouse doesn't consent to the conception. So the critical date at which that kind of crystallises is the date of conception. So the date of either the artificial insemination or the embryo transfer. So provided they're married at that date and both partners consent, then the spouse will be the other parent. So if the spouse is a man, they'll be the father. If the spouse is a woman, then there'll be a female second parent. And there's no particular forms, there's no process you go through. It's just a question of that's what the facts need to be at the time that you conceive. So if you are in a situation with an unmarried couple, So the birth mother is not married or in a civil partnership with her partner. Then there is a process to go through to create legal parenthood for the second parent. And this is something that can only be done if you have your treatment at a fertility clinic in the UK. So if you conceive through home insemination, if you go to a clinic overseas, this does not apply if you're not married. So it's worth kind of being aware of, because you may want to get married before you go through your treatment in order to avoid having to go through an adoption process post-birth. So if you're unmarried and you're conceiving at a UK clinic, you can go through this process of creating parenthood for the birth mother's partner by signing a set of very specific notices at the fertility clinic. So there's one for the birth mother to sign and one for her partner to sign. And those forms have to be completed correctly, and they have to be signed, and it has to be done before the artificial insemination or embryo transfer. So it has to be in place at the time the birth mother gets pregnant. It can't be done later. So it raises the obvious question of, well, what happens if that doesn't happen? So what happens if the clinic gives you the wrong forms, or they're not signed, or there's some kind of mix-up around this? Well, surprise, surprise, this has happened. And in 2015, the HFEA asked fertility clinics in the UK to carry out an audit of all their sperm donation cases involving unmarried couples to check that all the forms had been signed correctly at the right time. And that was because of a case that was heard in the family court where a couple had separated and there was a big dispute about whether the birth mother's partner was a parent or not. And ultimately it was found that she was not a legal parent. And so the HFEA asked clinics to carry out this audit, and shockingly more than 70% of clinics reported anomalies with the forms. And as a result of that, there were a lot of parents who were told by their clinics, oh, sorry, actually, you may not be a legal parent of your child, which obviously caused a huge amount of distress. And a group of those parents applied to the family court and asked for help. And the court found a very creative legal way of essentially rectifying the forms retrospectively so that they could fix the problem and make the parent who should have been a parent a legal parent. Obviously hugely distressing for the families involved, as well as hugely costly. And the court was really, really critical of clinics. So I know there's been a big drive since from the HFEA and many others to kind of really tighten up practice on this. But we're still seeing some cases where problems are arising. So clinics need really robust procedures, but also, if there are problems, there is potentially a way of fixing it in most cases. So not to panic. So co-parenting and known donation, and I just wanted to kind of explain what I meant about this, because there are lots of different kinds of donation that happen, and as I'm sure many of you will know, if you conceive with a donor at a UK clinic, that donor will now be an identifiable donor. So that means that you may not know the donor at the time you conceive, but your child will have the right to find out who they are once they reach the age of 18. So that is what we would call an identifiable donor, but we wouldn't call that a known donor. So when I say a known donor, what I mean is someone who is known to the recipients before they get pregnant. So it might be a family member or a friend who's donating. It might be somebody that they've got together with in order to conceive together. But the key point is that everybody knows each other before the conception takes place. So with known donation and co-parenting arrangements, sometimes they happen by conception at home. So you might have a single woman and a single dad, or a lesbian couple and a gay couple who are conceiving together, and they might do that by a private arrangement at home. Or it might happen at a clinic. So with an egg donor, obviously it would have to happen at a clinic. With a sperm donor, there's the option of IUI or IVF. And co-parenting and known donation arrangements are a complete spectrum of experience. They don't easily fit into boxes of it's donation, it's co-parenting. Most of them are kind of somewhere in the middle. And at one end of the scale, you have arrangements where you're working with a donor who's known to you, but actually that person is not going to be involved in the child's life at all, really. And then at the other end of the spectrum, you've got people who, are sharing parenting, and they're in that kind of co-parent definition. But a lot of people kind of fall somewhere in between. So I wanted to give you some examples before I tell you how the law works in these situations, just to kind of illustrate this spectrum. So at the kind of donation end, we've got Henry here, who's donating his sperm to his brother and sister-in-law. So he's very much acting as a donor. He's helping them conceive a family. But other than the fact, obviously, he's going to be this child's uncle and will be involved from that perspective, he's not going to have any kind of parental involvement. We've then got Jane and Gemma, and they're a married same-sex couple. and they're conceiving with their friend Fred, who's going to be an uncle figure. This is something we hear a lot of, this uncle figure. So something between a donor and a parent, not a father, not fully involved, not sharing parenting, but not quite a donor in the traditional sense either. So this is somewhere in the middle of the spectrum. And then we've got Sarah, who's a single mother, and she's agreed to co-parent with Stephen, who's a single man, and he wants to be a dad, and they're going to share parenting. Whether that will be 50-50 time, whether that will be a different proportion, but everybody involved in decisions about schooling and going to parents' evenings and so on. But this is more at the kind of co-parenting end of the spectrum. So you can see that this kind of covers a very broad range of different situations. So coming back to this legal parenthood question. So again, the woman who gives birth is the legal mother and the only legal mother. But in known donation and co-parenting situations, it gets quite complicated in terms of who the other legal parent is or might be. So the first in the pecking order will be her consenting spouse. So with the lesbian couple that we were talking about, the married couple, the birth mother's female spouse would be the other legal parent. If she's in a relationship with somebody who she's not married to, then again, those same rules apply in terms of that person could be nominated to be the other legal parent, provided that they're having fertility treatment at a clinic in the UK. If it's neither of those things, then it's likely to be the biological father who will be the legal father. So in those kind of known donation, uncle figure type arrangements, the donor may well be the child's legal father, and he will be if they conceive at home. So there are some circumstances in which the biological father would be a sperm donor if treatment happens through a clinic. But where there's an intention to co-parent, it's not quite as simple as saying that just because treatment happens at a clinic, he won't be a parent. So there's a lot of grey area around these situations. And some of the work that we do is to help people think about whether it's a good idea to put things in writing. So having a written agreement it won't change who the legal parents are. The law applies in the way that I've explained. But what it does is enables everybody to be very clear about that. So they all know what they're signing up to. And we sadly do deal with situations where things break down at a later stage. And very, very often those sorts of cases are situations where there was always a mismatch of expectations. The donor wanted to be involved, wanted to be a father. The recipients never really wanted that, and they didn't discuss it clearly enough at the beginning. So the value of the written agreement is not to kind of create a legal position. It's not to bind everybody into something, but it's just to give that clarity. So the court disputes that there have been in terms of kind of in the family court to do with known donation and co-parenting tend to be about one of two issues. So either the role that the known donor should have, so should he be a father, how much contact should he have, what should he be called by the child, that kind of stuff. And then secondly, whether he should be liable financially for maintenance. And that comes down to the legal question of whether he's a parent, whereas the first question is much more about what's best for the child. So there's a kind of different approach to those two different types of disputes. So I was just going to say something about surrogacy before we go on to the questions. So surrogacy is where a woman carries a pregnancy for somebody else. So she is carrying their baby and she does not intend to be a parent herself. So she might be carrying a baby for a different sex couple or a single mum who, for whatever reason, aren't able to carry a pregnancy themselves. She might be carrying a pregnancy for a same-sex male couple or a single dad who obviously need the help of a woman to be able to do that. She might also be carrying a pregnancy for a transgender parent. So it may be a transgender woman who's not able to carry a pregnancy. It may be a transgender man who, because of hormone therapy or surgery or because he doesn't feel that's appropriate to his identity, is not able to carry a pregnancy. So the options around surrogacy, these days the kind of court statistics show that there's about an even split between the numbers of parents who stay in the UK and the numbers of parents who go overseas. So in the UK, there are some restrictions. You can't advertise that you're looking for a surrogate, and there are restrictions on the professional services that can be provided around matching. So it's not a service that's provided by fertility clinics or profit-making organisations. So if you want to do surrogacy in the UK, you can look among your friends and family for somebody who might volunteer to help. You could go to one of the UK's 3 non-profit organisations, so they're Brilliant Beginnings, Surrogacy UK and COTS, that operate within the law, and they help parents and surrogates to find each other in different ways. Or you could look for an independent surrogate, and this is something that's really blossomed in the last 4 or 5 years with social media. So there are lots of Facebook groups where people make their own connections, and obviously that carries its own particular risks. But there is a real shortage of surrogates in the UK, and that is why so many parents choose to go overseas instead. And the big draws for going overseas are that there is a much clearer legal framework, and that it's much more easy to match with a surrogate because there is a process to go through for matching, which is much more certain than it is in the UK. So the places that people go tend to be the US and Canada, or the Ukraine and Georgia, which is a less expensive option, but only available to heterosexual married couples. So in terms of the legal issues, surrogacy agreements are not recognised in the UK. Everybody can agree that this child will be the child of the intended parents, but the law will not recognise that agreement. So when the child is born, the surrogate, as the woman who gives birth, once again, will be the legal mother. And once again, if she's married, then her spouse or partner will be the father or the other parent. And if you have a surrogacy arrangement in the UK and the child's born here, that's what will be reflected on the child's birth certificate initially. If you go overseas, so if your child's born in America, Canada, Ukraine, the law in those countries will recognise the surrogacy agreement, which means that the intended parents will go on the birth certificate in that country. But UK law won't recognise that. So the child will not automatically be entitled to a British passport, and the parents won't be legal parents in this country. So it's really important that parents kind of look beyond what the birth certificate might seem to say to what the legal position actually is. And in order to become legal parents of a child born through surrogacy, there is a process that parents can go through, and that's called a parental order. So the way that works is that the intended parents apply to the family court after their child is born. The process takes around about 6 months, so it's not instant, and there'll be 1 or 2 court hearings, and there'll also be a home visit by CAFCAS, which is the kind of family court social worker branch, if you like, that provide a reporting function for the judges. And with children born in the UK, that process is usually heard in the magistrates' court. It's quite straightforward, it's quite administrative. But international surrogacy cases and any cases that have any particular complications are heard by High Court judges. So a lot more involved and a lot more documentation required. So just to run through the criteria, if you're thinking of a surrogacy arrangement, it's always really sensible to make sure that you will qualify under these criteria for the parental order, because if you're not able to get a parental order afterwards, the legal issues will be much more complicated. So there may be other ways around it, but this is going to be the most straightforward way of doing it. So first of all, you have to have a biological connection with your child. So if you're a single parent, you have to be the biological parent. If you're a couple, one of you does. So you could use donor eggs or donor sperm, but not both. You can apply as a couple, or as from January this year, you can apply as a single person as well. One of you, or if it's a single application, you have to be domiciled in the UK. So if you're from somewhere else originally, there's quite a high bar for establishing that you have a domicile of choice here. It's not just about living here. So, that's worth just being clear about. Your surrogate has to consent to the parental order being granted, and her consent is only valid if it's given 6 weeks after the birth. So she has to have a cooling off period before she can surrender her legal status. There are some rules around payments which essentially say that the law prefers you to pay no more than reasonable expenses, but if you pay more to your surrogate, the court can authorise that. And the case law has developed to such a state now that actually it's pretty meaningless in the sense that the court will always authorise payments. So there's often a bit of a gap between what people think the law says and what really happens on the ground. And there's quite a broad brush approach taken in UK surrogacy to expenses payments. And then finally, the welfare of the child. So the court will make sure that this order is right for your child, but that's quite light touch. So unless you were a terrible child abuser or, something that would raise really significant concern for the court, welfare will not be too significant an issue. So I hope you're all sitting there thinking, well, this all sounds like a huge, ridiculous process to go through if you're having a child through surrogacy. And there's been a growing, gathering campaign for law reform, which will hopefully make things much easier. So we've already had kind of some steps forward in the last couple of years. So the reform for single parents is the kind of newest thing. And this came about because of a case that was heard in the High Court. We represented a single dad who had a son through surrogacy in the US. And we challenged the law, and the court said that it was breaching his human rights. And so the government put a piece of legislation through Parliament which has now allowed single parents to apply for parental orders as well. Last year, the Department of Health published a document called the Surrogacy Pathway. It's a really useful document, and it, for the first time, says that surrogacy is an accepted and positive form of family building, and it gives some really good information about how to do it as sensibly and responsibly as possible. So if you're kind of interested in surrogacy, Google Department of Health Surrogacy Pathway. The Law Commission is currently reviewing the wider law on surrogacy, and they're going to make some recommendations in 2021 to say how they think the law should be brought up to date. Obviously, it seems a long way away, but there's some quite complicated issues to work through, so probably sensible that they do that kind of slowly and carefully. And there'll be a consultation on that review later this year, so if you're interested in this, watch out for it. And certainly what we're hoping for is a move towards a proper recognition of what everybody agrees in a surrogacy arrangement up front, so the right people can be recognised as parents from the beginning. And we've got a petition which has been on change.org for a couple of years now, so if you're interested in this issue, feel free to Google it and sign. It's quite interesting as well because a lot of the people who've signed have kind of told their stories and why they're signing, so it's quite a nice collection of, you know, how the law is causing difficulties for people on the ground. So that covers all the issues that I was going to talk about. We've got a little bit of time for questions, and I've put our contact details up. If there's anything that I should say, there's loads of information on our website. We've got a knowledge centre with loads of stuff, so feel free to use it as a resource.
Thanks so much, Nancy.